Afternoon, everyone, and thank you for joining us for the AASA NASSP webinar on the new Title IX regulations, What School Leaders Need to Know. I'm Sasha Podolsky, the Advocacy Director for AASA and your moderator for today's presentation. And we're thrilled to have so many of you join us. And before I say anything more, I want you to know that the content we will be going over is intended to be shared with your colleagues in the field. So please know that this will be recorded, and we are encouraging you to share the slides and recording widely, as we're going to throw a lot of new and important information at you today. But first, a little bit of housekeeping. The first housekeeping item is to ensure everyone is connected to audio. Audio is accessible via computer or by dialing in on your phone. The second housekeeping note is that all audio, with the exception of our presenters, is muted and will remain muted throughout the duration of the webinar. We've muted the audio to ensure that each person has a quality experience. The third housekeeping item is about our Q&A segment. We have a lot of time for questions during the discussion. All questions will be fielded using the chat feature during that time, not the Q&A section. So please take time now to locate the chat box on the far right of your screen. And if you don't see the chat box, click on the chat icon at the bottom and it should appear. And although you may have questions for a particular presenter, we ask that you please send your questions to all panelists and participants as indicated on the screen in the pull-down menu. Type in your message and then press send, and we'll do our best to answer them at the end of our presentation. But we encourage you to post your question as they arise, as we may try to also answer them in the chat or during the Q&A segment. And the fourth and final housekeeping note is that we're recording today's session to allow all cohort members ASA and NASSP members to take advantage of our webinar. All participants in the webinar will be emailed a link of the recording as well as a copy of the PowerPoint presentation used in today's session. And that's it for general housekeeping matters. And now I'm so pleased to talk a little bit about our esteemed presenters from the law firm of Hogan Lovells, who are going to walk through the details of the regulations with everyone today. First, we have Megan Wilson, who is an associate at Hogan Lovells, where she helps education clients comply with federal, state, and industry-specific requirements. She regularly monitors industry developments in order to proactively advise clients on new rules, innovations, and best practices. Next, we have Joel Buckman, who is a counsel at Hogan Lovells and advises and represents education institutions and associations to public and private primary and secondary schools. Joel's practice has involved a wide range of issues, including the Office for Civil Rights and Department of Justice civil rights investigations, and faculty and staff labor and employment issues. And certainly, last but not least, we have Marie Sneed, who this year was the recipient of AASA's first Friend of AASA Award for the time and effort she's made over her career to help our association accomplish its goals and assist with the professional development of our members. Marie has done dozens of webinars and presentations on different K-12 legal issues for AASA, and has provided extensive counsel to AASA and our members, advising them on a wide range of state and federal legal issues, including those involving the Constitution, ESCA, No Child Left Behind, the IDEA, Title IV, Title VI of the Civil Rights Act, and much more, and she is a partner at Hogan Lovells. And a little bit about me, I've been with AASA for the past decade, and I handle a variety of issues for the organization on Capitol Hill, including special ed, Medicaid, career and technical education, and school safety and climate. And now for an overview of the presentation today. So here's our agenda. The politics of Title IX. How do we get these regulations? How did they come about? And what do they require? When should schools respond to sexual harassment allegations? How should schools respond to sexual harassment allegations? What else should schools and districts know? What happens next? Can the new regulations be delayed or stopped from taking effect? What should schools and districts start doing now? And finally, of course, our Q&A. But first, we're going to start with a little history lesson on how we got here. So I think most folks know that there are many different issues regarding Title IX that have received attention over the years, but these Title IX regulations focus specifically on sexual harassment and related acts of misconduct. So we're not going to talk about gender or pregnancy or bullying or athletics or other Title IX issues, because that's not what the regulations go into. And the reason for that is that while those Title IX issues have certainly been controversial and reviewed by the Office of Civil Rights in the past, the regulations that we're talking about today are clearly aimed at addressing sexual harassment and misconduct, primarily on college campuses. And this stems from high-profile cases at places like Penn State, Michigan State, USC, and the list unfortunately goes on. But of course, K-12 has had Title IX duties under the law as well, and while aside from the recent Chicago Public Schools case, it hasn't been a major focus of the media or for K-12 schools. It still, of course, remains an issue for us, and we're certainly impacted by these regulations, and the problems on college campuses are mimicked to a lesser extent in K-12. So the second piece is that even before some of these cases emerged over the last few years, enforcement of the law has become really contentious, particularly when the Obama administration issued guidance documents in 2011 and 2014 that advised higher ed institutions to ramp up investigations in misconduct and warned that their failure to do so could bring serious consequences. And these guidance documents serve to be a real wake-up call at the university level that more needed to be done to professionalize Title IX responsibilities. But many critics said that the guidance pressured schools to side with accusers without extending sufficient rights to the accused. And as a result, that prompted more than 600 lawsuits from individuals who alleged they were denied a fair process. And early in the DeVos administration, she made it known that she would be rescinding the Obama-era guidance. And in addition, she announced that she wanted to take a regulatory approach to Title IX. And this is a bit surprising in some ways, since Republicans traditionally tend to be averse to issuing regulations. But this is not a traditional Republican administration, as you know. And apparently she and others in the administration were very concerned by claims, that lives had been, quote, ruined because of false charges of sexual harassment and misconduct on college campuses. And she was determined to do more to bolster due process protections for accused students. And as soon as this was announced, particularly as it coincided with the burgeoning Me Too movement, the political reaction to these proposed regulations was fierce. Democrats perceived the administration of trying to take another step towards sweeping the scourge of sexual harassment under the rug, whereas Republicans believed, and to some extent continue to believe, that the final regulations balance fairness and support for survivors and relieve schools of some legal liabilities. Now, another thing to keep in mind is how these regulations will impact the Higher Education Act reauthorization in Congress. Many of us know that there's been a conversation for the past few years to reauthorize HEA, and with the pending retirement of Chairman Lamar Alexander from the Senate Education Committee, there's been a major push to try and get agreement on a massive overhaul of the Higher Education Act. These regulations, both the proposed and finalized, have really thrown a wrench into this process because of how far apart Democrats and Republicans are on this issue. And many people speculate that there was never going to be a way forward for a higher education rewrite simply because of this one issue. Now that we have the final regulations, though, it's not clear whether Democrats are more or less motivated to come to the table to do something to try and stop the implementation of these regulations. But as we are bumping up against the political calendar, and every day that Congress spends working on COVID-19 related issues is one less day they have to work on higher education reauthorization, it's not looking promising. In addition, the presumed presidential nominee for Democrats, Joe Biden, has already announced that he would immediately halt the enforcement of these regulations when he takes office and take steps to rescind them. So that's also not clear how that would change the political calculus of Democrats in a negotiation. And certainly if we have a change in administration, it's possible these regs would be on the books for less than a year, but whether the new administration would want to issue new regulations on Title IX or return to guidance is anyone's guess. And when the proposed regulations were released in late 2018, both AASA and NASSP came out against the regulations. And some of the concerns we had were how these regulations could actually undermine district efforts to address sexual harassment and assault and the ability of students to report abuse. We also were concerned with the administrative burden that this would create, and the fact that the regulations amount to really unfunded mandates at a time when districts are scrambling to find resources. They also create new and complex processes. But rather than talk about what the proposed regs did, let's get into the discussion about the final regulations and how you need to prepare to implement them in August. So I'm going to turn things over to Marie Sneed to get us started. Thank you.
Welcome to everyone. I see we have over 400 participants. We appreciate your joining us today, and from Hogan Lovells and our team here, we want you to know that we have been thinking about how our school districts and our friends and clients in the education world are challenged by what they have to deal with in their families during this pandemic, and not the least of how you professionally are having to think about opening schools. It's a daunting task, and it's a puzzle that I think everyone's going to have to work their way through. This slide just gives you what Title IX is. It's a very simple law, but it's the basis for the regulations, the Title IX regulations that we are going to talk about. And you'll see from our chronology that when the regulations were first issued by the Department of Health, Education, and Welfare, that was before the Department of Education was established, and there wasn't anything about sexual harassment as a form of sex discrimination there. And then from 1997 to 2017, we had a series of guidance documents, not regulations. The guidance documents, when you think about those, don't have the same force and effect that the regulations have. And that's one reason that this administration wanted to have regulations, because guidance documents can be pulled and new ones can be introduced, but regulations have to go through a much more sophisticated process to become a regulation. The department published those in 2018, and you can see how long it took that new regulations were first, the new regulations, this is the first time in 2020 when they have been issued. I want to pause for a moment too to tell you that we have struggled with these regulations and how they apply to the K-12 world, because as Sasha said, what the department was thinking about was mainly what was happening at the college and university level, not that we were perfect in the K-12 level, but that's what they were thinking about. And our systems are more complex in the sense that we have superintendent and we have schools. And so how you think about that and try to implement these regulations is challenging, because I'm not sure that the department completely understood it. I have thought about it because of my background, having been an assistant principal and principal before I went to law school. Not that there wasn't the law that we have now then, but thinking through how this works and now advising school districts over time. For example, we struggled with, there's an investigation process that we'll talk about more, and just to highlight it, one of the regulations say that you have to provide an equal opportunity for the individuals to present witnesses, including fact and expert witnesses. And they're obviously thinking more, when they wrote those regulations, I think, about formal hearings, which we don't have to have, but that's part of the regulation about presenting witnesses, fact and expert witnesses. There's also a requirement about the opportunity to present questions and answers, and the opportunity for parents, guardians, and students to review evidence. That's not how, as we all know, that the K-12 world works. We have elementary, middle, and high school students. So we just wanted to flag, that's the struggle that we've had about how to think through these regulations in a K-12 world. We can just go to the next slide, Megan, if you will. And this just shows the two guidance that were the basis for the Department of Education and thinking about their regulations. And then flip to the next slide, if you would. They withdrew the Obama administration guidance in 2017. They issued some temporary guidance for us. And then here's just why they did it. And I think the most important part of this quote, they say that the guidance documents may have been well-intentioned, but they have led to the deprivation of rights for many students. Both the accused students denied a fair process and victims denied an adequate resolution of their complaints. And you can just hear then in that quote that that feels more about higher education than what we do in the K-12 world, because of our interaction with students and investigations that we do that's just different than what happens in the higher ed world. If you go to the next slide, Megan. But the So what the Trump administration and Secretary DeVos is that she believes that the Title IX rules provide more clarity for schools, support for survivors, and due process rights. And again, there is some tension there between how this is implemented at the higher ed level and at the K-12 level. This slide we just put in because look how many comments there were. Over 124,000 comments when they published the draft regulations and said, what do you think about these? More than 124,000 people commented, and that says it all about the interest, concerns, and issues. And I know AASA weighed in on that. Sasha's mentioned that. Once they came, they were about ready to come out and people heard about it, and there was just, can we stop? We've got a lot going on. But the administration said, no, we have to move forward, and we believe this is necessary to strengthen Title IX protections for students. The interesting thing, we've given you a couple of quotes here, and if you go to the end of Secretary DeVos's, she said that she thinks it requires schools to act in a meaningful way to support survivors of sexual misconduct. Again, you think about higher ed, not that we have it, not that we don't have it at the K-12 level, but she says without sacrificing important safeguards to ensure a fair and transparent process. And you'll see as we go through, see what you think about what fair and transparent process means in the K-12 world. Go to the next slide. But we do recognize, and so does the rest of the world, that we're not perfect. And at the K-12 level, and Chicago Public Schools became a poster child for issues related to Title IX and sexual abuse and sexual assault. And in fact, there was a threat to cut off some of their federal funds. And now we have the ACLU has already filed a lawsuit to try to stop the regulations. If you go to, so now I'm going to focus on when should schools respond to sexual allegations. And generally it's, and think about it, it's you have to respond promptly, and that's not a change from the previous guidance, and not in a deliberately indifferent manner. That comes out of a case called Davis versus Monroe. And so the deliberately indifferent is your defense. You may find sexual harassment or sexual assault, and then the question is, what do you do as a school or district? And then the next one is when someone has actual knowledge of the sexual harassment. So the previous guidance said knew or should have known. This says actual knowledge, but we'll develop this a little bit more, and you'll see this is not so easy. And then obviously it says in its education program or activity. So everything in a school is an education or program or activity, and there's some limits when it happens off school grounds that it may not come, but we'll play around with that for a little bit. We had the press release on May 6th. They published the regulations on May 19th, and get ready. They become effective August 14th, just about the time that some of you are getting ready to start schools. We thought it might be helpful if you want to look at the new regulations, if you just click on this link, and you will find the text beginning at 30,572, and that may be helpful to you. I'm going to do one more slide and then turn it to Megan. We tried to come up with, in a nutshell, what are the basic steps? I've already mentioned it. So the school or the district receives actual knowledge of the conduct that could constitute sexual harassment. Now, this is one, when you look at the regulation, this is where we're trying to find some practical advice. the regs don't talk about a school-based Title IX coordinator. They don't talk specifically about a district level. They talk about a Title IX coordinator. But how school districts work, and what we know is you need a district level coordinator, and you need someone in each school that's your Title IX coordinator, because that's how things work in schools. And both at the district and school level, they need to have certain knowledge, and we will talk more about that. And they've also introduced here a very specific thing called an investigator. Once the complaint's made, then the investigator takes over and has to do a number of things, give certain notices, conduct an investigation, prepare a report, and then provide the opportunity for individuals and their parents review and respond to the report. I know people are thinking FERPA. Keep thinking FERPA. And then the fourth is decision maker. That's a fourth person. And so that person is supposed to provide the opportunity for involved individuals and their parent or guardians to prepare written questions to be answered by the other side. And the decision maker then reviews all the materials, makes a written responsibility, is the term they use, responsibility determination, decide who's responsible, and then it could include sanctions. So that's kind of an overview. We are going to flesh this out in the rest of the presentation. Megan, you want to start with the Title IX coordinator? Flesh that out a little more.
Thank you. Sure. So as Marie previewed for you, you have some key players when it comes to Title IX compliance. Because you're dealing with both the school district level and the individual schools that make up the district, oftentimes you'll have to figure out the best way to organize it in order for it to be effective to you. And so what we've laid out here is just a quick overview of the key players that Marie already previewed, and some things to consider in terms of their responsibilities and how this may look from a practical standpoint. So your Title IX coordinator, the new regulations require you to have one Title IX coordinator at least. But for purposes of compliance, it may make more sense. And, we recommend that you have district level Title IX coordinator, and you also have school-based Title IX coordinators so they can be on the ground and working with specific schools. The regulations outline various responsibilities that the Title IX coordinator would handle. Primarily, they're coordinating compliance efforts. So we know that the Title IX coordinator himself or herself could not handle all of the requirements that the new regulations provide, but they are responsible for coordinating the team and for ensuring that the steps are appropriately carried out. In some cases, there are certain responsibilities that only the Title IX coordinator can handle. And so in that case, you couldn't delegate it to the rest of your support team, but you need to know what those responsibilities are in order for you to determine what may best be handled at the district level versus at the school-based level. And so what we've done here is just broken out some of those responsibilities to kind of see what makes sense for a district level Title IX coordinator to handle, and what perhaps are responsibilities that a school-based Title IX coordinator would be best situated to coordinate. Okay, so at the district level, we know that there are certain responsibilities and certain materials that we would want standardized across all of our schools. So that district level Title IX coordinator could help develop those materials, make sure that the professional development is occurring at the school-based level, and that it's standardized and that people are receiving the same types of information. The school-based Title IX coordinator may be best positioned for handling specific incidents or sexual harassment allegations as they come up. So they would be kind of the on-the-ground person helping ensure that for individual cases, the school and therefore the district is responding in the way that it should.
The next key player that Marie mentioned was our investigator, okay? And the investigator investigates. We will flesh out some of those responsibilities as we move through the rest of the presentation. But one thing to know that may be helpful for staffing considerations is that your Title IX coordinator can also serve as the investigator. Okay, so they can have those dual responsibilities. And when it comes to addressing and responding to sexual harassment allegations, that Title IX coordinator can handle some of those initial steps, and they can also be the person that carries out the investigation process in order to collect the facts. And then we have our decision maker, which is one of our final key players for addressing sexual harassment allegations. Your decision maker is the one who is going to make that final determination. So is the person that's been accused of sexual harassment actually responsible for the conduct that occurred? The new regulations specifically state that a district may decide which standard of evidence they want to apply in sexual harassment cases. So you can choose the preponderance of the evidence standard, meaning that it's more likely than not that the alleged conduct actually occurred, or you can use a higher clear and convincing standard. The main thing to remember here is that that standard must be applied equally to cases that involve only students and to cases that involve students and employees. So once you pick one, you have to stick with it, no matter what position your involved individuals are in. One note that is very important with respect to the Title IX new regulations is who can be the decision maker. Okay, so before, it may have been for your school or for your district that the Title IX coordinator handled everything from start to finish. They were the person who coordinated compliance generally. If a complaint came in, they were the person who looked into it, and they were the person who gave the final decision as to whether the conduct occurred. Now, however, your decision maker can only come in that final step. Okay, so your Title IX coordinator cannot also be your decision maker. Your investigator cannot also be the decision maker. Okay, so the investigator could offer some recommendations based on the information that they uncovered during the course of their investigation, but it's the decision maker that has to be a separate individual that is responsible for making that final determination. Okay, so as we are digesting all of the new requirements, we wanted to just pause for a minute to highlight for you some questions that you may want to start considering. Like we said, districts may vary, schools may vary, and so you really have to think, what does this look like for you? So how can we put these regulations into practice so that we make sure that we're being compliant, but we're also making sure that we do it in a way that works for, the size that we are, or the number of people that we have that we can commit to Title IX compliance. So here are just some things to consider in terms of your coordination efforts and your staffing. Okay, so now we'll get into the meat of the requirements. So Marie already previewed for you generally what the new regulations require. And one of the threshold things is in order to know when you have to actually respond. Okay, so the new regulations use a term called actual knowledge. In the K-12 space, that simply means any employee. So any employee of the school, any employee of the district. Okay, so if any employee has noticed, meaning that they witnessed it with their own eyes, they heard about it because they heard rumors in the hallway, someone came to them and told them, or if they somehow just receive a report about it. So they get an anonymous note left on their desk. Any employee, whether it's an administrator, whether it's a bus driver, whether it's your maintenance staff, any employee, if they hear about conduct that may constitute sexual harassment, that means that your school or your district has actual knowledge. The next thing is that they have to have actual knowledge of sexual harassment. Okay, so what counts as sexual harassment? The new regulations provide a specific definition, and they essentially bucket it out into 3 categories. Okay, one is your quid pro quo, which usually involves an employee and a student. Okay, I'll give you this if you do this. So that's our quid pro quo. Bucket number 3 outlines specific types of conduct that are defined in other federal laws. Okay, so things like sexual assault, what does that mean? Dating violence, what does that mean? You have laws that provide those definitions, and so if the conduct meets that specific definition, it counts as sexual harassment. Category 2 is where your school or your district is going to have to use judgment, because from the regulations, the description for this category is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient, here meaning the district's, education program or activity. Okay, so this will require an assessment of, who are the people involved? What's the dynamic here? Yes, the conduct was unwelcome based on the alleged victim's interpretation of the events, but to a reasonable person, would it similarly be objectionable behavior? Okay, let's actually put this into practice. So let's better understand actual knowledge and the sexual harassment definition by looking at a few scenarios and figuring out what's going on. Okay, so we're focused right now on sexual harassment. So based on the definition of sexual harassment, we have 3 scenarios, and we want to know, is this sexual harassment? Okay. So you have a poll that just popped up for you, and we're going to ask you to answer yes or no for each of those 3 scenarios. So please take a minute and do that. Okay, and we should have our results coming in soon based on your responses. And so we want to know whether this counts as sexual harassment. Okay, and so we had several hundred participants respond, so thank you for engaging with us. The answer to each of these questions is yes. This is sexual harassment. The alleged conduct would count as sexual harassment under the new regulations. The first one is a quid pro quo, so that category 1. If you send me some nude pictures, I'll give you a passing grade. Category 2, you have a custodian, so it's not a teacher, but it is an employee. The graffiti is depicting sexual content and images, so that would count as a category 2, which is our severe, pervasive, objectively offensive. Okay, it does not matter that we don't have an identified perpetrator or an identified singular victim, here it still meets that requirement, that definition of sexual harassment. And then finally, we have a bus driver hears rumors that non-consensual sex occurred. And so this would count as our category 3. This is non-consensual sex. So this would be captured by sexual assault. We have a bus driver who is an employee. So actual knowledge has also occurred here. Okay, as Marie stated, the activity or the conduct that is in question has to have occurred in an education program or activity of the school or district. So this obviously covers things that happen on school property, but there is some question about what happens if something doesn't happen on school property, but it trickles over, the after effects trickle over onto school property, or perhaps it doesn't happen on school property, but it's still a school event. So here's another poll for us. Is this an education program or activity? So we have 2 scenarios here. One, so scenario A is a field trip where something happens. Scenario B is something that takes place on school, but the root of, or the kind of initial part, seems to have happened off campus because it deals with things online. Okay, so if we can get our poll back up, you'll see it on your screen, and answer that question for us. Do you think that this still counts as part of a school's education program or activity? And as you're answering that question, I see a couple of questions that have come in. One question asks, is it mandatory that there be both a district and school level coordinator? So the new regulations require that there be at least one Title IX coordinator. So by the technical definition, or by the technical requirement in the new regulations, one is sufficient. Okay. However, you have to take into consideration how your school operates and how your district operates. So is it actually feasible for one single person to handle everything that may occur across your schools? That's a question that you'll have to consider. Another question is, can the decision maker be a team of people? Yes, the department's guidance when they issued the new regulations, they responded to several stakeholder comments that were submitted, that 124,000 that Marie was talking about. And yes, the decision maker can be a team of people. However, none of those people can be the Title IX coordinator, and none of those people can be the investigator. Okay, we have the results from the poll. The answer to both questions is yes. Okay. So the field trip was a school-sponsored field trip. So that counts as education program or activity. Scenario B is a little trickier because you have some conduct that occurred, completely separate from school. The main thing here, though, is that it has now reached the schoolhouse. Okay, so it may have initially occurred completely offline and separate, but now we're at the point where someone isn't going to class because that alleged perpetrator is there and has been harassing them. So this is an instance where the school would need to step in, and you would have to consider, what conduct has occurred, during school hours or at school specifically, what conduct may have occurred outside. Okay, and then this is just a summary chart that compares some of the prior guidance. So when Marie initially went through kind of the history of Title IX, this compares just some of the prior department guidance to what we now have in the new regulations. So these are some things that you may need to consider because you may need to tweak your past approach a bit. Okay. So we've done a brief overview of when schools should respond to sexual harassment allegations. Now Joel will give us an overview of how schools should respond once they do have notice of sexual harassment allegations.
Thanks, Megan. So it's always good to start with the basics and at the beginning. And Marie touched on this, but just to circle back, when it comes to how to respond to sexual harassment allegations, and I would add again that what these new regulations are about, yes, they're new Title IX regulations, but the main focus is on sexual harassment, which is a component of Title IX and has long been a component of Title IX in terms of guidance, as we've discussed. So under the regulations, the legal standard for a school district's response to allegations of sexual harassment is that you not respond in a way that is deliberately indifferent. So you have to respond promptly and in a manner that is not deliberately indifferent. And as we've just talked about, you have that obligation when you have actual knowledge, and actual knowledge means essentially any employee has knowledge of allegations. What does that look like as a practical matter? And what do the regs say about how a school district would go about implementing that basic command? And there are a couple of, I think, rules of the road. The first rule of the road is once the Title IX coordinator has that notice, the first thing the Title IX coordinator has to do is get in touch, meet with the alleged victim, and at the K-12 level, involve the parents, and offer supportive measures to the alleged victim. And if the school district is going to impose discipline or take other actions against an alleged perpetrator or respondent that are not supportive measures, the district has to follow a grievance process that meets new legal minimum requirements. So you need to promptly meet with the alleged victim and offer supportive measures. And at that meeting, you would want to tell, and you're required to tell the alleged victim about what it would look like to file a formal complaint, and the consequences of doing so and the consequences of not doing so. And if the victim does not file a formal complaint, the basic consequences are you can't discipline the respondent and you cannot proceed with the grievance process and the investigation in the absence of that formal complaint. Have the next slide now. So another fundamental way that school districts need to comply with the new regulations, I mean, if the question is how do we do this in a way that's compliant, the first thing you've got to have is procedures that comply with these new regulations. Now, there are a number of requirements in the rules that say a school district shall have a policy or procedure or shall publish new information. And you can see that on the slide. So you have to publish your Title IX coordinator contact information. You have to have a general statement regarding non-discrimination on the basis of sex. You also have to adopt and publish grievance procedures that provide for prompt and equitable resolution of student and employee complaints alleging sex discrimination. That has long been the case, but then there's this and you have to have a grievance process which is specific to sexual harassment allegations that meets certain minimum requirements. Have the slide. So here we just want to pause to pick up on something Marie said at the outset, which is these regulations really were not written with K-12 in mind, at least in our view. But they do require K-12 school districts to adopt a grievance process for allegations of sexual harassment that is highly legalistic, and we would guess is going to require some significant changes to the way school districts would adjudicate or investigate or resolve disciplinary actions in general, and probably also the way school districts would go about handling a complaint of sexual harassment. And just want to give you a flavor of that with this slide. So we've talked about some of this, but these are requirements that need to go in the grievance process. Have to treat complainants and respondents equitably. You have to require an objective evaluation of all relevant evidence. You have to avoid conflict of interest or bias in key players in the grievance process. You need to have a presumption of innocence. The regulations say presumption of no responsibility, but it's just the way to think about it is the respondent is innocent until they're proven that they are responsible under your policy. You have to include reasonably prompt time frames, and with a few limited exceptions, school districts have some discretion about creating those time frames. Marie's talked about, and Megan, using either preponderance of the evidence or clear and convincing. School district has to choose between those two, and they cannot impose discipline unless they satisfy that burden of proof. Again, highly legalistic. So we normally pride ourselves on translating rules out of legal jargon, but I would just say here, there's really no substitute for sitting down with the regulation. We've given you the site on the slide, and perhaps with your counsel, looking at your current process and making sure you're adopting a new compliant process that meets the minimum requirements. So I don't think we need to spend much time here. It's just revisiting the basic steps outlined in the regulations. So actual knowledge means an employee hears about alleged sexual harassment. The Title IX coordinator meets with the alleged victim, offers supportive measures in the process for filing a formal complaint. If there's a formal complaint, there's an investigation stage where an investigator takes certain actions we're going to talk about, and then a decision stage and an appeal stage where a decision maker takes certain actions. So again, I think the rubber starts to hit the road once you've got actual knowledge of alleged sexual harassment, and that starts with the Title IX coordinator meeting with the victim. And the principal, or one of the first things you should do at that meeting is make sure you're offering to the student supportive measures. And the whole idea around supportive measures is that they're non-disciplinary, non-punitive services that you can't charge a fee for, that are designed to restore or preserve equal access to your education program or activity without unreasonably burdening the other party. So we've given you some examples here: counseling, extensions, etc. And just one point to note, you can impose mutual restrictions on contact between the two parties, but in general, you need to maintain the confidentiality of your supportive measures unless you need to share information about those supportive measures to implement them. And finally, you would need to give the alleged victim or the parents or guardians information about how to file a formal complaint. I've already mentioned this. There can be no investigation of the alleged sexual harassment until after a formal complaint is filed. The formal complaint has to be filed by the alleged victim or his or her parent or guardian. And it needs to describe the sexual harassment allegations and request that the school district investigate. The formal complaint can be filed essentially at any time as long as they're still at school. And a key point to know, the regulations say the Title IX coordinator should solicit the wishes of the victim about whether to file a formal complaint. But the Title IX coordinator may initiate a formal complaint on their own decision and sign one, which would initiate the investigation and decision process, provided that decision is not clearly unreasonable in light of the known circumstances. Okay, so we have a yes/no poll here, although I'm wondering, and I sort of think we should, I'm mindful of the time, and I'm thinking we should perhaps skip the yes/no poll.
I think
Marie
we
or
should.
Megan?
I agree with that. Yep.
All right. So let's assume you get through that meeting and the alleged victim says, yep, I want to file a formal complaint. So what happens then? The basic steps, and again, this is not, I know we've titled this, What You Need to Know. I would say with respect to the grievance process, this is an overview, and like I said, you need to dig in, but the basic steps are notice, investigation, written questions and answers, a responsibility determination, and an appeal. And again, you have to set reasonably prompt timeframes, which with a few exceptions are not specified. So notice, once a formal complaint is filed, a school has to provide to the known involved individuals, so the victim and the alleged perpetrator, written notice of the allegations. And that written notice can't just be, you know, there's an allegation of sexual harassment. It has to include sufficient detail, including the identities of the involved individuals if known, the conduct allegedly constituting sexual harassment, the date and location, and it has to include a copy of your grievance policy, which, as I've said, you know, would need to be compliant with the regulation. That notice must also include certain other information, like state that the perpetrator is presumed not responsible, and also include information regarding the range of potential sanctions or remedies, and provide that individuals can have an advisor of their choice. And on the advisor front, that advisor can include an attorney. So again, just to underscore the sort of legal nature of this new process. So when it comes to the investigation, you've got that notice. Now we're coming to the investigation phase. And on this slide, we've just included a few general points to remember. One is that it's not on the burden of it's not the responsibility of the alleged victim to prove that sexual harassment has occurred. That burden is on the school or the district. It has the burden to show that, yes, by preponderance or by clear and convincing evidence, the conduct occurred that constitutes sexual harassment. And the school and the school district may not restrict the ability of an involved party, so the victim or the alleged perpetrator, from discussing the allegations with their friends or trying to gather or present relevant evidence. So there are no gag orders. Okay? So what must the investigator do? Well, at a high level, the investigator investigates. And what that means is the investigator gathers relevant information, interviews witnesses and the victim and the respondent, and has to provide an equal opportunity for the involved folks to present witnesses and evidence. And again, underscoring the legal aspect of this, there are privilege considerations. So you cannot rely on privileged information or require the production of it. And I think another key point is once the investigator has gathered information, it has to make available to the involved individuals and their parents and guardians the evidence that it has gathered and give them an opportunity to comment on that evidence prior to completion of the investigative report. So prior to basically preparing the investigator's report, both parties have to have the opportunity to review and comment on the evidence, and there's a 10-day timeline in the regulations for that. And the last step for the investigator is to create a report that fairly summarizes the evidence, and as we said, it can include a recommendation. So the final step, and this is the one sort of accommodation the department made for K-12. At the higher ed level, there has to be a hearing, and I'm simplifying a lot, but there has to be an opportunity for cross-examination. At the K-12 level, there does not need to be a hearing, although there can be one. But what a decision maker has to do, a decision maker has to give the individuals and their parents or guardians the opportunity to submit written relevant questions to the other side, including witnesses, and explain any decision to exclude a question as irrelevant and provide each side with the answers to the questions and allow for limited follow-up questions. So basically, you have to include a process for written cross-examination, just to sort of be simple about it. And that is a key step in the process before the decision maker renders a decision. Next slide. So finally, the decision maker will evaluate the whole package, the investigator's report. I should have mentioned the parties have an opportunity to respond to the investigator's report, and that would be in front of the decision maker. And then the decision maker applies the standards under the policy and renders a decision that, but it's not so simple as responsible or not. The decision maker has to issue a written decision. It's almost like a judicial opinion that identifies the allegations, describes the procedural steps, lays out responsibility determinations, including findings of fact, and outlines appeal procedures. And quickly, there has to be an opportunity for appeal. The grounds for appeal are procedural irregularity, new evidence that could affect the outcome not previously available, conflict of interest. And the decision maker on appeal can't be the same as the decision maker, investigator, or Title IX coordinator. A quick slide on dismissal of a formal complaint. So there are certain cases where a school must dismiss a formal complaint for purposes of Title IX sexual harassment, and there are certain cases where it may. So where it must dismiss a formal complaint is the alleged conduct, even if true, isn't sexual harassment. Or even if it's true and it would be sexual harassment, it didn't occur in the district's education program or activity or in the United States. And you can make that determination before launching an investigation where that is clear. There's also discretion to dismiss a formal complaint where the alleged perpetrator is no longer enrolled or employed by the school district. And I just want to pause to say these grievance procedures, this grievance process applies to allegations of sexual harassment, whether perpetrated by a student or an employee, just to underscore that. And then there are other situations where you may dismiss a complaint, including where there's notice to the Title IX coordinator in writing that allegations are withdrawn. Okay. And back to you, Megan.
Thanks. So instead of going through the actual polling process for this putting the regulations into practice slide, let's just go through it together. So scenario A, only the alleged victim can file a formal complaint of sexual harassment. That is false. Okay, so yes, the alleged victim or his or her parents can file a formal complaint, but if they decline to do so, the Title IX coordinator also has the authority to file a complaint. And the standard for that is if the circumstances that the school or the district knows, if it would be clearly unreasonable for them not to investigate and look further into it, then the Title IX coordinator should proceed and file the complaint. But like Joel mentioned, if you do not have a formal complaint in place, either signed by the alleged victim or by the Title IX coordinator, you cannot proceed with the rest of the grievance process. B, supportive measures must be offered to an alleged victim, even if a formal complaint is never filed. That is true, okay? So your supportive measures is the first step once you have actual knowledge of sexual harassment allegations. The Title IX coordinator must meet with the alleged victim, and in the K-12 space, also his or her parents and guardians, and offer the range of supportive measures that may be available and appropriate in this situation.
Let me jump in.
C.
I saw a question about supportive measures. So it could be counseling, it could be thinking about, do we need to separate the victim and the perpetrator, there are a range of things, and that's really educationally up to you about what you think would be supportive. The regs just simply provide some examples.
Thanks, Marie. C, the Title IX coordinator can also be the decision maker, but cannot be the investigator. This one is false, okay? And I saw some questions in the chat box that related to this. So let's go through that one more time. So your Title IX coordinator can also be the investigator. But when it comes to the decision maker, that is not the case. So your decision maker has to be a new person. It cannot be the Title IX coordinator, and it cannot be the investigator. So the decision maker only enters the picture at the very end. So it cannot be any of the people that have been used earlier in the process. And then last, D, a district can decide whether it wants to offer an appeal process. This one is false, okay? The new regulations say that an appeal process must be offered, but then they go into specifics about on what grounds would the argument be for an appeal, okay? So the appeal process has to be offered, but there are only certain reasons that an alleged victim or an alleged perpetrator can use for why the decision should be overturned on appeal. And then this is another summary chart, as we have had before, about requirements that have changed from the 2001 and 2017 department guidance over to the new regulations. So just a few examples, not exhaustive. Okay. The last thing that we wanted to highlight in terms of the how should schools respond is that there are certain professional development requirements that districts should meet, and there are also certain record-keeping requirements that must be met. Okay, so your professional development is your training. Okay, the regulations say that you must train certain people. So your key players, your Title IX coordinator, investigator, decision maker. We'll soon get to informal resolution, which is what some of you have been asking about in the chat box. So those people must be trained on certain topics, but as a good practice, you should be training everyone at your school and district so that they're able to understand what their responsibilities are when it comes to addressing or reporting sexual harassment allegations. Okay. And these are just some topics that the new regulations say must be addressed in your professional development materials. So these are reflected in the new regulations and must be a part of any training that you provide. With respect to record keeping, this is just documentation that demonstrates that the school or the district has been complying with the Title IX requirements. Okay, so as Marie first mentioned, your defense is, I was not deliberately indifferent. What I did was not clearly unreasonable based on the circumstances as I knew them. And so your record keeping is just documentation to support what you have been doing and how you have been responding. Okay. And then once again, putting the regulations into practice. These are just some questions to get you started in thinking about what needs to be done with respect to your professional development materials and with respect to creating systems in order to properly maintain the types of records that the new regulations require. So conversation starters.
We're running short on time, so I think we should skip this slide.
Okay. So our next section is just on what else should schools and districts know. So this is kind of our potpourri of other things that are contained within the regulations that are, especially worth noting. I think I saw a question in the chat box about whether putting someone on leave counts as a disciplinary response. The answer is no. So a school district may place an employee on administrative leave for the duration of the grievance process. Okay, so that is one of the exceptions to the general rule that you should not discipline an alleged perpetrator until after the grievance process is carried out. There's also an option for emergency removal, and the new regulations outline the steps or the process that the school district or the school must undertake before they make a determination to conduct an emergency removal of a student before the grievance process has been carried out. Here's some information on the informal resolution process. And so you can read the slides to get a flavor for what is required. The gist is that you as a district can decide whether you want to offer some type of informal resolution process. You can think of it as mediation, but essentially you are offering an option to not have to go through all of the steps that Joel carried us through with respect to notice, investigation, written questions and answers, your determination, and then perhaps your appeal. If you offer this, it cannot be offered in cases where an employee is the alleged perpetrator. Okay, so it's just unavailable to them in that instance. But in other cases where you have a student respondent or a student alleged perpetrator, an informal resolution process may be offered. You cannot offer it until after the formal complaint has been filed. So in the same way that the formal complaint has to be in place before the grievance process is carried out, a formal complaint must also be in place before you offer some type of informal resolution process to those involved. And this is a discretionary opt-in, and it's also a voluntary opt-in and also a voluntary opt-out. So just because the individuals, the alleged victim and alleged perpetrator, agree to participate in an informal resolution, they can withdraw from it and resume the normal grievance process that Joel previously laid out for us. And these are just a few other aspects of the new regulations. There are provisions with respect to retaliation. There is an option to consolidate formal complaints if you're dealing with a set where it's the same facts and circumstances. And then as Joel mentioned, hearings are discretionary for K-12 purposes. So you must have your written questions and answers that we already reviewed, but you can choose whether you also want to conduct some type of hearing. And if you do so, the regulations provide some discretion for districts, not in the same way that they do for colleges and universities, which have more prescribed requirements in the regulations.
I think we should, we're getting very close to the end, and I'd like to have some opportunity for questions so you can see the slides, and then just go quickly to the very end where, well, what are examples of district actions that you need to consider, and this is probably clear, to review and revise your procedures, review and revise your codes of conduct and handbooks, professional development for everyone. And someone mentioned, I saw in the chat about should you do professional development or training of students? Absolutely, that's key, and that's the next one. And then put information early and often on the website about the process and the Title IX coordinator and professional development. I know there are a lot of questions. Sasha, I'm not sure how to manage. I was kind of listening and
No
trying to
problem.
work it through. So what do we do? How do you want to do it?
So unfortunately, we're not going to be able to get to all the questions. That's just I've never seen so many questions on this. And actually, that kind of if you could move to the next slide really fast. We are going to do one more after that. We are going to do another webinar with the Association of Title IX Administrators. That's going to be exclusively a Q&A style webinar on the Title IX regulations, and that will be on June 30th at 2 p.m. Eastern. And so a lot of I think some of the specific questions that folks have asked for clarity on that we just can't get to today, feel free to join us for that, or, you know, if you've had a chance to unpack this, you can join us for that as well, and registration will open next week. But I'm just going to highlight a couple of the questions that I thought that we got in the time that we have, which is about 5 minutes. The first one is, as we look at the fact that our schools are going virtual, how are schools responsible for sexual harassment that occurs over the internet and outside of school, even though some of this may take place during the school day under the new regulations?
Yeah, if it comes to school and, you know, you're conducting a class and doing digital learning, then in my view, it's the same as being in school. It will be challenging, but if you have actual notice of it, then you're going to have to do follow-up. I think the investigation is going to be challenging. That will probably have to be remote. The good thing is school is ending soon. And remember, these don't go into effect until August, so you've got a little time. But it will apply because it's happening in a school event or activity.
Okay. And do the new rules provide an exception for confidential employees at the K-12 level? So if they report to, say, a social worker, are they obligated to report the name of the student and details to a Title IX coordinator?
Joe, you want to take that?
Yeah, a couple points about that. The first thing to say is that the regulations say K-12 school has notice when any employee, so it says all employees, and repeatedly in the preamble, there's a reference to all employees, and one of the examples is a counselor. So that's on the one hand. So I think by the book, all employees means all employees. However, when it comes to the actual investigation process and the grievance process, there's a prohibition on accessing, considering, disclosing, or otherwise using a party's records that are made or maintained by physician, psychiatrist, psychologist, or other recognized professional or paraprofessional acting in their capacity. So I think there's a little bit of lack of clarity around that, but that looks to be the state of play.
Great, thank you for that. Another question, how would the processes and standard of evidence be put into a governing board policy in your mind?
Joe, you want to take that, or Megan, one of you?
Well, I guess I would say I'm not sure it would need to go in a governing board policy per se. It could, but I would look at what you have today, because presumably school districts do have today processes that would apply to allegations of sexual harassment. That would be the starting point. Line it up with what's in the new regulations, and again, there's no substitute for just diving into that and then building out a new policy and deciding how to promulgate it. And I would just promulgate it consistent with the way the district promulgates other policies.
And I would think in terms of big pieces. For example, you want the definition, right? And you want the pieces of the grievance process in terms of the topics. Think about what's policy language and what is procedure language, and try to separate those.
Right. And then I think this will have to be, unfortunately, our last question, given how much content we went over. But in terms of the issue of that was brought up before about mandated reporters and child abuse statutes at the state level and how this interacts in terms of K-12 staff. Does this regulation change anything there, or does it impact anything in terms of how enforcement of this regulation would impact enforcement that happens already through some of the child abuse statutes in states?
No, if there is an allegation or an observation of child abuse, that's a separate bucket of things. So you've got, if you're a mandatory reporter, you got to report. You don't investigate that, you report. You then, if there's a Title IX problem, you can investigate the Title IX problem, but you do need, if you're a mandatory reporter, you got to report it. And then they have to do their thing. The same thing if there's some issue that there's a violation of a criminal law, you may need to report to the police, but that doesn't absolve you of, you're in a civil context here, of then marching through the steps that we've outlined today.
And I would just quickly add, in the preamble to the rule, the department says there is room to coordinate as you execute the grievance process with law enforcement in terms of timelines and deadlines.
Right. Okay. That's very helpful. Well, I'm sorry that we don't have more time to answer your questions, but as we mentioned, June 30th, you'll have another chance to get just questions answered. And so I want to have a big thanks to Marie and Joel and Megan for putting together such a comprehensive presentation today. I hope you use it, share it. You'll get a recording and a copy of it automatically if you registered. And thank you so much for making time and taking time out of your busy schedules to be part of this and to learn about this new regulation. And thank you all for making time to educate us.
Thank you very much to everyone.
Thank you.